My name is David, and I'm one of the admissions counselors at InGenius Prep. Today, I'm going to talk to you a little bit about disciplinary addendums and how to handle them. Handling disciplinary addendums for your applications can be an anxiety-ridden process. This is the case even if the event that precipitated the disciplinary action you're disclosing isn't particularly embarrassing for you. You might be thinking, why would an admissions committee choose me over someone with a similar GPA and similar test scores from an equally respected school when I have this kind of blemish on my record? For some more general advice on disciplinary addendums, you should read my article on this topic, which you can find on the InGenius Prep blog that's now linked to this video. I'll tell you that the conventional advice, which I agree with, is toward over-disclosure. Right now, we're going to take a look at a specific example from a highly competitive law school applicant's application. Right now would be a good time for you to pause the video and take some time to read the redacted sample addendum from one of our students who was kind enough to let us share her story. Now that you've had a chance to read the addendum, let's start to deconstruct it line by line. Obviously, you now know that this relates to alcohol in some way, so bear in mind some of the strategies that this student employs in her near-final draft very early on in the addendum. You'll see in the first comment that I've highlighted where it says that she's 22 years old at the time of the incident, I say that she's acknowledged that she's over 21. While this is a very subtle detail, it could be important because it instantly primes the reader and clears up that this wasn't an underage drinking related violation, which some admissions officers might regard as more serious than what happened here. I've highlighted the term open container in the second comment because it's inconsistent with the term public consumption used later. The term open container could bring up images of having an open container of alcohol in a car rather than a public consumption violation, which many consider to be less serious as well. Whatever the case may be, we advise the student to clear up which violation it actually was. The third comment, also a very small, subtle detail, I've highlighted that it was a playoff baseball game. This sets the stage that the occasion on which this incident happened was a special occasion. It helps to dispel the notion that the applicant was an out-of-control party person that had some disregard for the law and for the consequences of her actions. Now, the next highlighted sentence or two in comment 4 is highlighted because it shows that the amount of detail that she included could be construed as making excuses, but the way that she's done it here seems to be that it just says that she's meeting her family, that provides as much detail as possible, and in my mind, it makes it seem more reasonable. That, again, she's not an out-of-control party person. This was a special occasion. She was not randomly drinking. She was meeting her friends, consenting adult, or meeting her friends and family, and she was a consenting adult. In the fifth comment, I highlight the term public consumption task force. This is somewhat important, and it shows that while not trying to disclaim responsibility for her actions, she shows that the police were specifically out to get people for this type of violation. They were concentrating on it on that particular evening, and she's able to do this without sounding like she's making too many excuses. Now, the cumulative effect of the amount of detail she had above, the public consumption task force mention, the playoff baseball mention, could start to build up to some people and some admissions readers to say, you know, this person's making excuses. So instantly the student shifts and tries to dispel that notion. She takes responsibility in her last sentence of this paragraph and transitions away from the excuse type language that's masked in detail. She says, I answered his question honestly and he proceeded to write me a ticket. This is a nice way of saying that I acknowledge responsibility for what I did, but without writing it in such a way that explicitly draws attention to the fact that this was a violation of the law. The next paragraph is an absolute admission of responsibility, says that she learned her lesson and fully accepts the consequences. And it shows maturity. It shows personal growth and that this was a mistake that she would not repeat again in the future. And this is the kind of thing that admissions readers are looking for. They want to know that your youthful indiscretion was something that you learned from and something that is not a recurring pattern. So Our general comments is that this addendum might try to include a little bit too much strategy. A simple admission of guilt, accepting consequences, and showing maturity is more effective in certain instances, but overall this is very good. And the former admissions officers on our staff that gave it a read said that it didn't strike them the wrong way, that the tone was acceptable, and that they liked the amount of detail that was included. So, as a note, this addendum was part of a successful application that was, the student was ultimately accepted to 5 top 10 law schools. So, if you're worried about some kind of youthful indiscretion that you've experienced, it's not necessarily going to cost you your admission to these schools. Remember, admissions readers are human beings. They understand that things happen. It's what you do with it after the fact and the way that you treat the situation that matters most.